for the court that argument. I'm young and I'm dumb and I'm in my late 20s and I can't control my impulses. That's usually for teenagers. All right, thank you. All right, so Deputy Mejia, Deputy Laura, if you'll take him into custody and counsel, you need to be back here at 11 and the court will make its decision. 22 CR 4259W, State of Texas versus Renee Angel Cantu. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
Roy Barrera, Jr.
All right, and are you Mr. Cantu?
Good morning, Your Honor. Yes, ma'am.
All right, you entered a plea on April 2nd of no contest in each of these cases. The court found there was sufficient evidence to find you guilty in each of the cause numbers. Have both parties had a chance to review the PSI report, state?
Yes, Judge.
Defense?
Your Honor, this is the same PSI
Yes.
that was prepared for you when you first placed him on probation. So yes, we have.
No. I haven't placed him on probation.
Yes, Your Honor, he's on probation. And you gave him probation with all of these cases pending.
Just one moment. Could I see another file on Mr. Cantu?
And Judge, yes, that is correct.
All right. I only have 2 files before me. That's why.
I have the PSI if you'd like to see.
Oh, no. I'm wondering if you all have any objections to the PSI.
No, it's the same PSI that we've seen before.
All right.
6-year probation. We applied for 5. So she gives us 6.
All right, thank you. All right, and each of the cause numbers, according to the plea bargain agreement, the state is opposed to your application. And it states in here that this is running concurrent with CM 105821.
And I think, Judge, that's one of the 2 cases, I think back when this pled, that waiver number may not have existed. So
Yes.
They just use this again instead.
All right, and they're taking in consideration CM 104043, NIMAG number 712122 and 712121. All right, state, you are opposed?
Yes, Judge.
All right, any witnesses from either side?
Just my client, Judge.
All right, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
All right, you can lower your hand, state your name for the record.
Renee Cantu.
All right, defense, you
Good
may
morning.
proceed with direct examination.
Thank you, Judge. Good morning, Mr. Cantu. How old are you, sir?
I am 33 years old.
Okay. And are you currently on probation in this court?
Yes, I am.
All right, and what are you on probation for?
I am on probation for a possession of manufactured delivered 4 to 200 grams that happened, I believe, in 2021.
Okay. Now, when you applied for probation in that case, which the court just ordered up, all of the matters that you've taken care of with Mr. Neil Cordero, they were all pending and included in the PSI that the court placed you on probation for. Is that correct?
Yes, sir, that's correct.
Okay.
All in 2021.
But since that time, most of those cases, the majority of those cases have been disposed of, either taking them into consideration or just outright dismissed.
Correct.
And now you're before the court on 2 of the cases that were pending before we even applied for probation in the case that you're on probation
Oh,
for.
yes.
Is that correct?
Yes, sir, that's correct.
Now, is it true and correct that since the court has placed you on probation, no violations of your probation have ever been filed or have occurred?
That's correct, not one. And I've been on this monitor for 3 years and since then.
All right,
and
so-
all good.
You're on a monitor for 3 years, no violations of the monitor.
Correct.
You've been drug tested for 3 years and no violations of any drug testing.
At
You've
all.
been, suffice it to say, 100% clean
Correct.
and in 100% compliance and in obedience with the court's probation.
Correct. And I don't know if the court remembers, but they gave me like a list of 9 things to do.
Correct.
Like intensive outpatient treatment, 12 weeks, a 90-day program, like just 9 separate things, but I've completed all of them. So yeah.
All right. And are you gainfully employed?
Yes, sir, I am.
Are you full-time employed?
I sure am.
And so suffice it to say that on page 2 of this PSI, the court was informed of this myriad of cases that occurred prior to you being placed on probation.
Oh, yes.
Okay.
Yeah, they knew it before, since 2000.
And obviously, these cases are now disposed of, except for two that are before the court today.
Correct, yes, sir.
Okay. So have any negative consequences occurred in your life since the court placed you on probation?
Not with
The court.
the court, but with myself, of course, I'm like, so when I wrote the court a few times ago, I really didn't mean disrespect when I said, I'm not one of these hoodlum thumbs or thugs. I really did mean that. Like, I used to
Be a
mess up.
hoodlum.
Yes.
You used to be a hoodlum thug.
Yes,
That's
ma'am.
what you're saying.
So, like, I didn't mean it in a bad way, no offense, but I thought I was Billy Badass, excuse my language, but obviously that wasn't for me. So that's why I have done everything good now, because that life was stupid.
Okay,
like,
so here's the thing. This is the point that the court wants everybody to get to. Number one, when he was placed on probation in this court for that drug case,
Mhm.
the state was silent to his application.
Mhm.
When I accepted that plea, I was not given any of the facts of this because these were unindicted cases.
Correct.
So I would like for us to get to the point as to the drug dealing,
Mhm.
because when the stipulations that were entered into, that everybody agreed, these are the steps. He's selling drugs and he's moving a large quantity of drugs. That's why this is over, I think, 200 grams. And the case that he's on probation for is not. The case that he's on probation for is, I think, 4,200.
correct.
And these are over 200 grams.
Judge, when the offense that he's on probation for occurred, he was involved in drugs, clearly. They're all stated on page 2 of the old PSI. And Your Honor, all of that is history. And it is obviously known to this court by virtue of the fact that since you have been in control of his life, placed him on a monitor 3 years ago, he has respected all the rules and regulations of the law and of this court. And so we cannot deny his history. It is there before you. It was for you clearly when you respectfully granted him his probation. Judge, he has made a 100% turnaround from the life that he was living. That is not who he is today. And he has 3 years of sobriety to show for his really a miraculous turnaround. Can I finish?
Yes, sir.
Thank you. So we respectfully submit that he has proven to this court in every way that he is sober, he is gainfully employed, he is making an honest living for maybe the first time, and all due to this court's surveillance and this court's observations and this court's control. There is no reason to believe that he cannot successfully complete any term of probation that you would consider placing him on. To incarcerate him after he's made such a significant change in his life, Judge. I mean, this is a success case. We don't have a lot of them in this world of ours, but he has proven himself in every single way imaginable to this court. So the purpose of the state being opposed to his probation, well, clearly, historically, I respect their position. But to oppose probation today, after the man has lived a law-abiding life, a peaceful life, and a hardworking, diligent life as far as being lawfully, gainfully employed, to throw all of that in the toilet and incarcerate him would serve what purpose? I mean, clearly punishment is punishment, but probably God is the only person who knows how much he has punished himself over his young years. You know where his father is. His father's in the penitentiary for dealing drugs. You know from the last hearing, when we asked you for probation, this man is grown up in CPS world, going from home to home to home to home. Not a mom, not a dad.
Okay, I
Growing
understand
up.
your
Yeah,
arguments,
yeah.
but do you have any more questions for him?
Yes. Do you believe that going to the penitentiary after you've changed your life would benefit you?
Not at all.
Do you believe that it would benefit anybody in this courtroom or anybody in the community because after 3 years of sobriety, now you're locked up? Would that help society?
No, that would be kind of dumb.
Okay, well, are you a contributing member to this community today?
Oh, yes, for the past 3 years, yes, now I pay tax. I do everything legally now.
Oh.
Kind of side note. So yes, I just want you to hear for my own mouth.
That's fine, there's no question.
All right, so I tell you what, counsel, if you finish your
Yeah.
questions, then I'll allow state to
Thank you, Judge.
do cross-examination, and then
I'll
if
pass
there's
the witness,
anything
Judge.
you wish to address with the court, you can. State, it's your cross.
Judge, sir, just looking very quickly at this PSI, one, did you review it with your attorney?
Yes,
Well, we're aware that during one portion, it says the defendant denied suffering any abuse as a child and reported CPS was not involved in his childhood.
no, I was in CPS for from 9 to about 17 years old.
So why would it be in the PSI that your attorney didn't object to that CPS wasn't involved? And this is all stuff that they're getting directly from you.
I was in Child Protective Services my whole, from St. PJ's, from St. Jude's, yeah, like I could name them, Low Ridge.
Okay, so just going back, also looking at your criminal history, you agree with me, you have quite an extensive criminal history.
Yes, sir, I do agree with you.
And being out of Denver, it would be a assault to drugging victim where you did get probation. You were given 4 years probation, and that probation was revoked.
That was like a lesser charge. It was a regular fight, except to like a plea. Like the plea that I had, it
Right,
had
but-
to
but
be
you
something
agree
about
that
drugging.
You have that in your.
Oh, yes, when I was 19 years old, I'm 33 now. I was a teenager.
Okay. And again, it was revoked on that back in 2020, correct? It says
Mm,
right here in the PSI. granted
The case
removal.
happened in December 21st, 2014, I believe.
One other
It
thing-
happened when I was 19 years old.
One other thing I wanted to ask or get into really quickly was, what's changed? What exactly has changed?
I grew up, I'm not kidding anymore. I was hurt. I was angry. And I know I can't blame anybody for my childhood. Like he's like, yeah, your mom's dead, your dad's, who cares? Like I'm an adult now. Get over it. You have stuff to do. You have to be an adult, you have a job, you have everything. Be a man,
At the time of this offense, the offense that you're here before the court, who was living with you at that home?
I was actually hopping around at that time.
Okay.
So I did need money. So I was trying any little way, to get money at that when that happened.
And again, this is after you've already been arrested for other cases and already had issues with drugs in the past, is that correct?
No, I've never had a drug issue at all in my lifetime until these drug cases. Never in my life. So once again, that drugging victim is a regular fight out of Denver, Colorado when I was 19, except the plea had to be assault with drugging victim, but there was like no drugs involved at all. That was just like part of the plea.
Okay. Nothing further from the state judge.
All right, any other questions?
That's all, Judge.
All right, I have a question.
Yes, Judge.
So everybody, when they come before me, they're always talking about me. My question is, what do you think was happening with the drugs you were selling?
What happened? Say it again. I'm
What do
sorry.
you think was happening with the drugs you were selling? What do you think they were going?
Hurting lives.
Mhm. And you continued.
Yes. Yes, ma'am.
And why were you selling drugs?
Because I needed money and I believe I had a job working at a warehouse. And I went from making like $6,000 a week to maybe 300-400. So that was not, I was so used to like living with $3,000 or $4,000 for my rent, for everything. So I started like panicking, like, oh dude, I need money, you know? So that's when I thought I was Billy Badass, and I wasn't.
Oh, yeah. So walk me through this. So you are working.
Yes, ma'am.
So how do you reach out to somebody saying, hey, I want to sell some drugs for you?
So I was kind of in the ghetto, the west side, and it's not hard at all. Like you literally just go right there. Tell someone, Lupe, hey dude, you know, what do you want? You have everything there. So of course I initiated, I'm like, hey, I need some money. Like, what can I do? And then yeah, that's how it. I'm like, okay, you want to work? Well, here we go. And literally, like the second time, that's when the officers like, oh yeah, by the way, I'm an officer. Like shit.
Okay. All right, any other questions?
No.
Any other witnesses?
No, Your Honor.
All right, court will hear argument.
Judge, the state's gonna argue here that I think he should at least get the 10-year minimum. These are a lot of drug cases that are all coming in very rapid succession. He also has a very extensive criminal history. The state asked what's changed between now and then, and there really wasn't an answer that was given. There was no details as to what he's done, other than being on under court supervision, where he knows if he tests positive for drugs, that's something that can get him in trouble. If he does anything out of line or commits another offense, that's something that's just going to make it worse for him. So again, it's something that we haven't really had any detail as to what exactly has changed. So the state would ask for 10 years in the prison.
All right,
Judge, his entire criminal history was known to the state when this court placed him on probation. Nothing negative has occurred. Everything positive has occurred. This is a successful probationer. This is someone who has changed his life around. I don't understand the logic. What has changed? This man has changed. The man before you, Exhibit A, has changed. His entire criminal history is spelled out very clearly when the same state of Texas recommended probation.
oh, I
Or
think
at
they were
least-
silent.
or remain silent. And no objection at that time was offered by the state when this court granted him probation. Judge, this court has helped him, as he said in here. Why do you want to be on probation? And he said, because it'll be my mentor. And you, whether you have agreed to or not, have been his mentor. You, whether you knew it or not, have had a very positive impact on this man's life. And Judge, I can't underestimate the strength of the statement. He has not stepped across the legal line in 3 years. How can we punish him today for what happened when he was 19 or 20 or 21 or whatever? And
I
these
think this is
cases,
from 2022.
these cases were already pending when the court considered everything and placed him on probation. He has not disappointed you. He has not disappointed probation. He has not disappointed anyone. His employer loves him. He is a hard-working, sober, contributing member of this community. To throw his life away and give him 10 years in prison, Judge, I don't see what good would come out of that, because he has demonstrated that he not only can talk the talk before you today, he's walked it. Every step, Judge, he's walked with you, with your probation office. I mean, thank you. He's not who he was because of this court. And now, at the last minute, to pull the rug out from under him and say that we need now to protect society from what you did back before I gave you probation, I don't see the logic in that. What purpose would be served to incarcerate a middle-aged man who admitted that he was a young, want to be the person who did not respect the
I mean,
law?
he wasn't young, because this is in 2022, so it's 2 years ago. He tells me he's in his 30s.
Correct.
So doing young and dumb things is usually teenagers, not people who are in their late 20s. I mean, that,
Yes, I understand.
for the
that.
court, that argument, I'm young and I'm dumb and I'm in my late 20s and I can't control my impulses, that's usually for teenagers.
Sure. And that statement was going to all of that history that was brought up by the state, you know, in Denver, Colorado, and here and there and everywhere. That's where that statement was going. Judge, he admitted his guilt. He came before this court. These cases have been pending a long time, and he has never absconded from the jurisdiction of this court. He's never missed a court date or a court hearing. And, you know, he has patiently waited for this day to arrive, and it has. And I just would ask the court to consider the good that this court has done in this man's life, and why, you know, throw the baby out with the bathwater at this time, Judge. It's you know, 10 years of probation. He's done so far so good. You can still give him the 10 years the state wants you to give him today. You can give it to him tomorrow, next week, next month, or next year.
All right, thank you. Anything else from the state?
Judge, again, these few cases that you have before you, you didn't have this information whenever you decided to give them probation the last time. It's because they were still pending. They hadn't been indicted yet. There was no movement on them. Now that they have come forward, this is what we offered based off of the facts that are in these cases. Again, the court did not have these before. You have them now. You have the ability to take this into consideration. This isn't a teenager who's making bad decisions. This is a grown adult. It's a grown man. He made these choices and the consequences that both of them.
All right, thank you. All right, so Deputy Mejia, Deputy Laura, if you'll take him into custody, and counsel, you need to be back here at 11 and the court will make its decision.
Thank you, Judge.
All right.
You're on, I'm on the video conferencing with the State Board of Pardons and Parole.
Sure.
Exactly at 11. It'll only be about a 30-minute.
Oh, that's fine.
Can I come back? Brett?
Yes.
Okay, thank you.
Thank you. It's Roy Guerrera. All right, Norma, could I see the file on Renee Muñoz's client? It's Jason Gonzalez.
Oh, yeah. Yeah, she has it.
Just one, right? Something? I thought it was just.
All right, Jason Gonzalez, if you'll come forward. Hello.
Hello.
Hi, thanks for dressing appropriately for court. Your attorney is ill, so we're going to give you a short reset, okay? Ms. Ferguson, on Jason Gonzalez, if I can have a reset for 14 days. Criminal Trial Division, Jason Gonzalez is going to be reset for a couple of weeks.
Thank you, Judge.
I just don't have the application.
I judge, we can be back in July 23rd.
All right, so we'll bring you back on July 23rd. Once you sign the reset form, you're excused. All right, just have a seat. They'll call you back up to sign the reset. Juan Arambala. Hello, thank you for dressing appropriately for court. All right, today is plea deadline date,
Yes, Judge.
and where are we?
So,
Is this going to be, good morning, is this going to be an agreement? And I'm sorry, if you could introduce yourself to the court reporter?
Hi, good morning. I'm Jonathan Watkins and I have Christian Vega with me. Good morning, Judge.
Good morning.
Your Honor, at this time, the defense would respectfully request a trial setting.
All right, Ms. Ferguson, I need a jury trial setting on family violence. How long do y'all expect this trial to
Just a
last?
few days, Judge.
All right, so it's 2 days.
1 second, Judge.
And if you all, before you leave, if you can make sure you do an acknowledgement of discovery.
Yes, Judge.
Yes, ma'am.
So how's it been going?
Judge, we've been blessed. Busy though. Yourself?
Oh, busy.
Yeah.
But there's a storm barreling towards Louisiana, so I have to make sure I check on my family, make sure everything is okay.
Judge, I can do September 9th.
All right, September 9th would be your jury trial date.
It's impacts, just so they know. Judge.
All right,
Yeah.
and it will be impact court.
How impactful?
We shall see. All right, any other questions?
No, and we're going to continue to confer with the state, Your Honor. We have an open line of communication. We appreciate that.
All right, so once you sign the reset form, you'll be excused. Just have a seat, and attorneys don't leave until I've received the acknowledgement of discovery.
And hope everyone stays safe, Judge.
Oh, thank you so much. You guys have a good one.
Yes, ma'am. Thank you, Judge.
You're welcome. Have any objection to this attorney standing in?
No, I do not.
All right, so Ms. Humphries, the reason why you're in custody is that you didn't report for your TAP evaluation and PSI. Why didn't you report?
I had to work that day and I wasn't able to reschedule my my appointment with the medical records.
For what?
For medical records, because it's by appointment only with the clinics and I have to
All
retreat.
right, so your number one thing was to report. Do you understand?
Yes, ma'am, I do.
All right, so what do you do for a living?
I work for Ashton Carter. I retrieve medical records by appointment only. And
Judge, I have some of her pay stubs here if the court would like to see
All right,
them.
no, just give me a moment. So specifically, what do you do in this medical field?
I retrieve medical records and I have to upload them for certain insurances and stuff like that.
All right, so you're trailing off. You need to speak up so the court reporter can hear, and more importantly, so that I can hear, because I'm making the decision on whether or not I'm following this plea. And if I cannot hear you, guess what? I end up making assumptions, and I don't want to make assumptions. Do you understand?
Yes, ma'am.
All right, so you say you retrieve medical records,
Yes.
and this location you working at, do they have medications there?
Do you have medications? No.
All right.
Well, I work in the medical records department at different facilities.
Alright.
So, yeah.
And do they know about your history?
Yes, they do. But see, I work for Ashton Carter and Ashton Carter sets me up with appointments for different clinics, but I'm not in the medical part. It's in the back office part where there's no medications or anything like that. It's just like an office setting.
So is he aware of your criminal history and that you have this possession case?
I'm not sure if they know about this possession case, my
Well, I
recent
mean-
one, because they haven't run a background check on me recently, but
So did you
I've
tell
been there
them?
for a
That will
while.
be a no, correct?
no, I have not told them.
All right,
my
so you need to
recent-
tell them.
I will definitely tell them, let them know.
Do you have any children?
I do.
What are their ages
16, 15, and 13.
and where are they now?
Right now, they're at home.
Who's at home with them?
Um, Daniel Nihishihara, who I live with.
Sorry, who?
Daniel, my friend Daniel.
Who is your friend Daniel?
He's my friend. I don't know. He's just a friend.
And I'm sorry, give me your ages of your children again.
16, 15, and 13.
All
My
right,
13-year-old is at my grandma's house. She lives with my grandma.
She lives with your grandmother.
Yeah.
15-year-old, is that a girl or a boy?
He's a boy.
16-year-old, girl or boy?
He's a boy.
All right, why is your 13-year-old living with your grandmother or her
Um,
grandmother?
Because she decides to live over there. She prefers to live with my grandma.
And how long have you known this Daniel person?
Since what, 18 years probably, before my oldest was born.
Does he know about your drug use?
He knows that I got in trouble with this charge, yes.
So my question is, does he know about your drug use?
He knows I had a drug problem before, yes.
And does he know specifically about this charge?
Yes.
And does he use?
No, he does not.
And is Child Protective Services involved?
They have an investigation for a retaliation thing, but it had nothing to do with this charge.
What is the retaliation about?
My friend's boyfriend decided to call CPS on me out of retaliation just to get us away from him. It's a long story, but
Oh, what did they allege when they called CPS?
that I left my kids alone at his house and I was supposed to return when I got my income tax or something like that. But it was not true. He just wanted us to get away from his boyfriend, so because he had just gotten out of jail and we were there helping him. And yeah, he was just abusive, so he wanted me out of the way
All right, so he was abusive?
towards his boyfriend, and I was there helping him while he was in jail, so we were there helping him and he did that.
And you allowed your children around that person?
No, he was in jail, so we don't talk to them anymore at all, but
All right, anything else?
Your Honor, and you know, I did speak to Ms. Humphrey, and she relayed to me that she did try to contact probation to, you know, get that PSI cleared up before this warrant was issued, but she just had the issue with her work, where the appointment was made, and so she contacted, and I know the court is not concerned about the PSI at this time, but
Well, no, she had a choice to make. Her choice was either do her PSI, which would result in this court following this agreement or not, and she chose not to. That's where we are.
understood, Your Honor.
All right. Anything else you wish to say on her behalf?
Nothing else, Judge.
Anything else from the state?
No.
All right. This is what the court is going to do. Court is going to sentence you to an $800 fine. That will be probated. 4 years deferred adjudication. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And probation, she is not allowed to work in the medical field unless they are aware of this charge. So you need to have them write a letter with the contact person at your work, saying that they're aware that you're charged with this possession less than a gram case, and they still want you to work for them. Do you understand?
Yes, ma'am.
There's to be regular reporting by Zoom or in person. And Ms. Abrams, even with that letter, she's still not allowed to work around medications. She's not allowed to be a home healthcare provider, and she's not allowed to have employment involving children. I'm going to do the UA hotline until further notice. Probation will do a TAP evaluation, and that'll be done out of custody. If she missed that TAP appointment, file a motion to revoke and follow TAP recommendations. If TAP requests inpatient treatment, we'll start with intensive outpatient treatment. There's going to be 120 sober meetings and 120 days. Take in consideration 2024 CR 3189. 120 hours of community service restitution. How far did you go in school?
I graduated.
All right, so what are you planning on doing with the rest of your life, employment wise?
I was in the medical field, for medical assisting, and I wanted to open up my own billing company, doing medical billing and coding,
Mhm.
but I don't know if that's an option anymore.
No, it doesn't appear to be. Let me explain something to you. You're on probation for a drug case where you obviously have an issue with drug use. So you're not allowed to be in a medical field where you dispense medication, work around anyone who has to take medication. Do you understand?
Yes.
All right, 120 hours community service restitution. I'm going to order parenting classes. Once she completes parenting classes, the community service hours will be deemed satisfied. There should be CPS compliance. Field visits. One time per month. Until in treatment. And probation, whatever the TAP recommendations recommend, we are going to start with intensive outpatient treatment. Probation, is there anything else she needs?
Okay.
Is there anything else you need from the court to be successful? Is there anything else you need from the court to be successful on this probation?
Mhm.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, and I'll ask that the warrant be recalled.
There's no, sorry, just clarification on the record. It's for 4 years stay, not 3 years?
Yes.
Okay.
Okay, you'll take a seat in the box.
Thank you, Your Honor.
You're welcome. Cesar Gutierrez.
Yeah, Mr. Mora's not here. You can
Okay.
fill in the box.
All right, Mr. Mora. Where are you? Come
He's right
forward,
there.
please. Mr. Mora? Yes, we're going to recall you back for September 10th. There's a doctor who's going to speak with you. Do you have any questions?
No, ma'am.
All right, we'll see you back on the 10th, okay?
Thank you.
You're welcome.
You may be excused, Your Honor.
Yes.
Thank you.
Cesar Gutierrez. Yeah, I was wondering about that. Oh, thank you. Well, we say someone, we know who, don't we? All right, today is the plea deadline date. So, jury,
Yes, Your Honor.
All right, thank you for dressing appropriately for trial.
I believe the state is going to be asking for continuance, Your Honor.
All right. Well, can I see the state, please, on this case?
Your Honor.
All right, Mr. Young, today is, I know it says jury trial on the docket, but our jury trials are on Tuesdays. So those are the cases that go to trial. How much time do y'all need for a jury trial on this?
I think it would be less than a day, Your Honor,
All right, so probably 2 days because we do jury selection.
probably.
State, do you anticipate this jury trial lasting past 2 days?
No.
All right, so Ms. Ferguson, can you put Mr. Gutierrez for the next trial setting? It's 2 days, it's criminal trial division. It should be short. And then state on this one, before you all leave, if you will prepare an acknowledgement of discovery.
Yes, sir.
All right, and once you sign the acknowledgement of discovery, you will be excused.
And are we coming back tomorrow, Your Honor?
Let's see, she's gonna give me a date,
Judge, August
August 6th.
I'd prefer the 9th of July.
I know, the only thing is that we have, what do we have tomorrow? Is it a murder trial?
that's the following week, Judge, we have a lot of cases. Well, no trial division, and then we have family law.
Okay,
My understanding is the state is going to try and dismiss and re-indict, Your Honor. So I'd like to have that done as quickly as we can.
Okay.
And we'd also like it to be a summons rather than a new bond. Since
Okay.
it's not really his fault that this is happening.
all right, state. Are you all anticipating on re-indicting this case?
Yes.
All right. And when do you anticipate seeking to do that?
That I do not know because I do not know how quickly or slowly cases are being brought to grand jury by our intake division.
All right, then let's do this. If you could perhaps give Mr. Young the intake attorney's number where they can contact him and let him know when they anticipate taking this to the grand jury so that he doesn't need to make another bond.
Yes, Your Honor.
All right,
And I will accept whatever the court tells me to do.
all right. And Ms. Ferguson, what date did you say?
August 6th.
All right, so we'll be back on August 6th, and that will be your jury trial date.
Thank you, Your Honor.
All right, you're welcome. Once you sign the reset form, you will be excused, and then defense, once you sign the acknowledgement, you will be excused.
Thank you.
All right, thank you. All right, state you're excused.
Appreciate it, Your Honor.
You're welcome. And Norma, on that case, if they re-indict, make sure it still tracks with the jury trial for August 6th. All right, we have two people in the waiting room, a Mary Ann Olivares and Joe's iPhone.
One of them might be, Terrence Courtney. I know he was having one time with Ninja.
Okay,
And she was trying to get a hold of him.
all right, let's see. We'll see who we have here. You need to unmute, sir. What's your name?
Yes, Jose Gonzalez.
Okay. Just give me a moment.
Okay.
And sir, you need to have a seat and find a stationary place.
Okay.
All right, and Miss Marianne Olivares, you need to have a seat and unmute. All right, Miss Olivares?
Uh-huh.
Yes, who is your attorney?
I don't have an attorney. I'm actually here to speak for Mr. Gonzalez.
She had the
All
kids.
Okay, just give us one moment. And we're gonna wait for
Okay.
your attorney to appear, Mr. Gonzalez. I'll put you in the waiting room, and as soon as she appears, we will come back.
I'll give her a call right now.
Thank you. Adele Kassan,
Gator.
I think, is his first name Gator or is it Adele?
It's
on this side.
Gator. Oh, sorry. Gaston Gator, Adele's his middle name.
Okay.
Kurt Hopkey for defense. Hopkey.
I'll get your name. I'm sorry, but it's.
You're good.
All right, who's the prosecutor on this case? All right, a failure to remit tax.
Yes.
All right, so where are we on discovery?
I have a lot of paper. I don't have any media or anything like that. I'm not sure if there is any, but we'll double check with the state. I'm probably gonna need to do an AICE motion to get my fraud examiner on this. This is a financial crime type thing, and it's a lot easier when I have somebody to explain it to me.
All right, Ms. Ferguson, on this case, can I have a 30-day reset for discovery, and whatever motions you need to file, counsel need to be filed by that date?
No problem, Judge.
All right, thanks, Nick.
Absolutely.
Oh, wait a second. You have to get the date. Just a second.
Oh, sorry.
I can do August 6th.
All right, we'll be back on August 6th. All right, and thank you for
That's not
dressing
a good date
appropriately
for
for
me,
court.
Judge. But I can negotiate with Norma.
No, you negotiate with the court. And really, it's not a negotiation. Whatever date I say, that's the date you have. So when can you be here?
Actually, yeah, August 6th, never mind.
All right, Ms. Ferguson, if you'll give them a reset form for August 6th, and that will be for discovery. Thank you.
Have a seat.
Thank you.
Thank you, Judge.
You're welcome. Christopher Esquivel. Good morning. Hello, thank you for dressing appropriately for court.
Thank you.
All right, and if the attorneys, if you'll state your name for the court reporter, she's learning everyone's name.
Perfect. Go ahead.
Allie Jackson, the state.
Alfonso Cabañas for the defendant, Christopher Esquivel.
And who do you have with you?
Judge, and this is Ashanti Wilson. She's a second year at Tech Law School.
Oh, we're not gonna hold that against you. Well, welcome. You're always welcome to come to court anytime. Are you enjoying law school?
Yes.
Yeah, I always tell people, after your first year, it goes by so quickly, so enjoy it.
Thank you.
You're welcome. All right. So we need a jury trial date. How long do y'all expect this trial to last?
2 days, Judge.
All right, Ms. Ferguson, 2-day for family violence. When are they up? Do we think the other case is going to go?
And the one in next week?
Yes. Is that going to work
It's a
out?
strong possibility. I'm gonna try.
Okay.
I need to talk to one of the.
All right. So Ms. Ferguson, on this case, put it for next week. Or whenever family violence is up next.
Yeah. It's that, or I think like the first or second week of August would be the next one after that, yeah.
August 6th, second week of August.
It would be August 13th.
Okay, so here's my question. So this week is criminal trial division. Next week is family violence.
And it was requested by the state and the defense for next week. We have to actually very good.
I'm sorry, what?
You just put Mary Diaz that week, just because that was the date that defense attorneys and the prosecutors approached you on.
Yeah, no, that's fine. So what date is that? The Mary Diaz date?
It's the 16th.
16th.
Yeah.
All right, so put this on the 16th. They're saying that things may work out, so 16th.
16, works for me, Your Honor.
All right, so that's a tentative date. We may be in a murder trial. If we are, then it's not going to go. All right, so we'll come back on July 16th. Is there anything else?
No, Judge.
All right. Once you receive the reset form, you excuse. Thank you for dressing appropriately for court.
Thank you, Judge.
All right. Okay. Thank you. Everyone, the court is taking its recess at noon. So if your attorney has not appeared, it would probably be best for you to get on the phone and call them. Otherwise, you're going to be back here in the afternoon and the weather is going to be bad, but we will all be here. And can I see the file on DeAndre Scott, please? Joseph Ramirez.
Joseph Ramirez.
Are you all ready to proceed?
No, Judge, I've talked to my client, and he wants to retain counsel, so he wants a reset to come back with a retained attorney. Try to assist.
State, are you ready on Ramirez to proceed with a contested?
No, I haven't.
All right, so Mr. Ramirez, today is the day for your contested hearing. So if you have an attorney that you want here now, they can be here now. But this case was set on June 13th for today for a contested hearing. If you wanted to hire an attorney, you should have already hired one. So here's the thing, we're going forward today.
Okay.
All right. All right, thank you.
Let me confer with my client. Please.
Sure.
Thanks.
DeAndre Scott, if you'll come forward, please. Hello. Hi, thank you so much for dressing appropriately for court. Your attorney sent a message to the court that she is ill with a sinus infection. I know how those are. So we are going to recall you. Do you wish to continue with the attorney you have?
No.
You don't? All right, just have a seat and we'll see if we can have another attorney appointed to represent.
If she's sick, I'll just keep her. I'll talk to her. She's gonna try to help.
All right, so if not, just let the court know.
Okay.
I'll keep it.
All right. Ms. Ferguson, recall this for Thursday. Are you employed?
I am. Can I do it on a Monday? I'm off Mondays.
All right, Ms. Ferguson, recall this for the 15th. This is going to be the last reset with this attorney, okay?
Please, thank you.
You're welcome. And it's DeAndre Scott. And Mr. Scott, that's your plea deadline date, so you need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, ma'am.
All right, thank you. Otillo Espinoza Ruiz.
We are present.
All right, where is your client?
Mario Mohammed.
Judge, on this one, I think at the last setting, we've done a discovery setting to get some video over to the defense.
Mhm.
I was informed today that there were 2 videos that they were still missing.
Okay,
So I'm in the process of downloading that right now.
all right, so it will be available though.
Yeah, I guess, Judge, I'm putting it on a flash drive today.
All right, so what we're gonna do on this case, and how long do you anticipate that video is?
It's a pretty sizable file, Your Honor.
I started downloading it to the flash drive, whenever Mario brought it to my attention earlier this morning. It's still downloading one of the videos.
All right, so Ms. Ferguson, if you can recall this for the end of July for a plea deadline date, is that enough time, counsel?
That should be perfect time, Your Honor.
July, I can do July 30th.
Right, your plea deadline date is gonna be July 30th. Thank you for dressing appropriately for trial. Once you sign the reset form, you excuse.
Yes, thank you.
Thank you. And state on that date, I'll also need an acknowledgement of discovery sign.
Yes, ma'am. Yes. Thank you.
Kevin Wright. Sir, you need to have a seat. Oh, what's your name?
My name is Perez. My name is Gutierrez.
First row, sir.
Yes.
In the first row.
All right, and Norma, if you can let Adrian know his client is here. Hello.
Good morning.
And counsel, if you'll introduce yourself to the court reporter. All right, counsel, you're on this side. All right, where are we on discovery?
Judge, I think we've received all the discovery in this case, and we would like to have another pretrial if we could.
All right, were they able to tender an offer or no?
They did this morning.
Okay. How old are you?
21.
All right, Ms. Ferguson, set this for the second week in August for a plea deadline date. And it's Kevin Wright.
To follow up a little further.
All right, Ms. Ferguson, if you can reset this for the end of July, is that enough time or you need more?
That should be enough time, Judge. Previously, when reaching out to the complainant, he's been pretty responsive. So hopefully it shouldn't take that long to get a hold of him.
All right, so Ms. Ferguson, if you can put this at the end of July, please. All right, so we'll come back on July 29th, and that will be the, hello, Ms. Garcia,
Hello, Judge.
and that will be the plea deadline date.
I'm on trial that day.
All right, Norma, do it the week of July 22nd. All right, we'll be back on July 23rd. Yes.
I won't be here. I'll have a doctor's appointment. I'm supposed to get a hysterectomy.
Oh,
Can we do first week of August?
well, obviously you're male, so you don't know about hysterectomy.
It's just
and how
the,
painful
it's
that
the,
is.
yeah, it's just the.
You're just like throwing this out.
It's-
Oh, I'm having a, you know, it's like, oh, I'm having a baby on Tuesday. Okay, we can do that on Wednesday. No, sir.
Yeah, it's just the consultation thing, but I can't miss it.
Okay, no, we won't let you miss that. All right, the 25th?
That's fine.
All right, Norma, can we recall this for July 25th? I mean, can you believe that? I don't even know why he was a part of that conversation. Leland, why you in the part of the conversation?
You just gotta take a seat on it.
Yeah,
Yeah.
all right. All right, so July 25th, and that will be the plea deadline date.
This is on the docket.
Thank you. Could I see the file on Christian Almanza? Thank you. Joseph Ramirez. Yes. And counsel, if you'll introduce yourself to the court reporter.
Albert Chidas for Mr. Joseph Ramirez.
Court is calling 2021 CR 8084B, State of Texas versus Joseph Ramirez. Can I have parties announced for the record for the state?
Jason Garrett.
Defense?
Albert Chidas for Mr. Ramirez.
And are you Mr. Ramirez?
Sure.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
That's fine.
Are you the same Joseph Ramirez who's placed on community supervision in 2021 CR 8084B for the offense of tampering with the government record on January 10th, 2023 for a term of 6 years? Is that you?
Sure.
All right, state.
Yes, Your Honor. Violated condition number one, on or about the 19th day of December 2023 in Bear County, Texas. The defendant Joseph Ramirez committed the offense of tampering with government record. Violation condition number one.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, we waive the remaining violated condition.
Any objection?
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, and sentence you to 6 years in the prison?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes.
Court will find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor.
Yes.
And it is for both individual officers, community supervision and reforming the underlying sentencing to 3 years in the Texas Department of Corrections. And the state will take into consideration 2 cases, Your Honor. Night mag number 743.
Oh, I'm sorry, just 1 second. The printer went off. I don't know why they don't have a printer that doesn't make so much noise. That's okay, Deputy Laura. All right, so night mag number?
743-173, which is the tampering that he pled to. Then also county court case number 14, 735-036. Your Honor.
All right, is that the agreement?
That is the agreement, Judge.
And counsel, are you asking the court to follow that agreement?
Yes, Your Honor. And also, as of today, my client has 168 days credit. We would just ask the court to give him credit for that time.
And Mr. Ramirez, are you asking the court to follow that agreement? I'm sorry?
Yes, sir.
Are you waiving your right to appeal?
Yes.
All right. Mr. Ramirez, I don't understand the tiers. Here's the thing. You were placed on probation. You were given an opportunity. You were given an opportunity to live in the free world, but instead you took your opportunity and you committed new offenses. So that's a prison sentence. Do you understand? So the fact that you are here in this position, that's 100% on you. That's not on your attorneys.
I understand.
You understand?
Yes, ma'am.
So
I'm just crying
these
for
are
my family.
consequences. Well, here's the thing. With your family, you're crying for your family because you're not going to be there. You could have been there.
I
But you
understand.
chose to do this.
I understand that.
Yeah. All right. Court is finding violation condition number one true. The court will grant the motion, follow your agreement, sentence you to 3 years in the prison, give you credit for any time served, taking consideration night mag number 743173, county court cause number 734036. And the previous no contact order will remain in place. And how many children do you have?
5.
What are their ages?
They rank from 24 to 17.
All right, and there's to be no contact with minors. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor. Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your rights to appeal, you do not have the court permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, so we can go off the record. Here's the thing. If you want to do better in your life, then do better in your life. Don't continue to commit crimes and then, cry for tears for your family, because you know what? You had a chance to be with your family
I
and
understand
you
that.
chose not to.
Understand.
Maybe you don't want to be with them. I don't know. Maybe this is a way to avoid them. Sometimes I have friends who will work 24 hours a day. And when I say 24 hours a day, I really mean like 18 hours. And we're like, why are you still at the office? It's 2 a.m. And you know what we discovered? He doesn't want to go home because he has a lot of children. And he'd rather say, I'm at the office. So maybe you want to go to prison and not be around your family. You need to make your decision and make your mind up. If you want to be with your family, you're going to have to do better. You understand? And be a good example for your children. All right. Good luck to you. All right. Who's here for John Michael Garza? All right. Where's John Michael Garza? All right. All right. So this is jury trial?
Yes.
All right. Is there a family violence case in here?
You should have an assault as
I
well
think
as the evading judge.
All right, I have, there it is. And I'm assuming you all are taking precedent with your case?
Like, I have no idea. Brandon, I've never spoken about this case, Judge. He just told me we were gonna approach. And I said, okay.
All right, if you all will speak about the case and confer and then come back.
Okay, Judge.
All right, thank you.
Sorry, I didn't know it yet. Jesse, you?
All right, Christian Almanza. Have you conferred with the state?
Yes, ma'am, and I believe they tendered a dismissal already signed by the court.
Yes. All right, so Mr. Almanza, do you want to go to prison?
No.
So you're gonna have to make different choices in your life, you understand?
Yes, ma'am.
Otherwise, you may end up in prison or maybe end up at the Bexar County Jail, brought over in Orange. If you don't want your life to turn out that way, just follow the rules. You understand?
Mhm.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
I did. Coaching, yes. Yes, ma'am. You good to go? No.
Alfonso Diaz. Punishment is to be assessed at 180 days in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, have there been any such motions?
No, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Should be contained in Exhibit 1 and attached, Your Honor.
Any objection?
No, ma'am.
State, you may be excused.
Thank you, Your Honor.
Mr. Espino, did you review the document entitled Wavering Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, ma'am, just asking the court to honor our agreement.
All right, the court will find you guilty. The court will sentence you to 180 days in the state jail facility, give you credit for any time served. There's to be no contact with Gabriel De Jesus or any malls, shopping centers, or any store whose main source of income is not food items. So you can still go to HEB, but you're not to go to Target, you're not to go to Marshall's, you're not to go to Ingram Mall, you're not to go North Star Mall, any mall, that means Lock and Terror, anywhere. You understand? You're
Yes,
just
ma'am,
shaking
Your
your
Honor.
head up and
Yes, ma'am,
down.
Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes, ma'am, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, Your Honor.
All right, we can go off the record. How old are you?
I'm 38.
All right, so you need to ask yourself that 2 pieces of costume jewelry that you stole from Marshall's, is it worth 180 days of your life?
No, ma'am, Your Honor.
Well, you're gonna have to start making hard choices. Either you want to be in and out of prison for the rest of your life, or either you don't. If you don't, then stop doing this. You understand?
Yes, ma'am, Your Honor.
All right, good luck to you.
No, but I can try.
Alfonso Diaz. Each time Michael Rain is here, I lose him. Oh, there you are. Are you ready to proceed?
We're ready, Judge.
All right, Alfonso Diaz. Alfonso Diaz, come down. And Mr. Rain, if you'll introduce yourself to the court reporter.
Michael Rain for the defendant Alfonso Diaz. Yeah, the G is to confuse court reporters. They
Court
never
is
forget
calling.
after that.
2021 CR 2957, State of Texas versus Alfonso Ruben Diaz. Can I have parties announced for the record for the state?
Daniel West, State of Texas.
Defense?
Michael Rain for the defense.
And are you Mr. Diaz?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alfonso Ruben Diaz, who was placed on deferred adjudication in 2021 CR 2957 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on December 8, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
State?
Violating condition number 1, on or about the 18th day of March 2024 in Bear County, Texas. Defendant Alfonso Ruben Diaz committed the offense of possession with intent to deliver controlled substance PD1 in violation of condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes.
Court will find violation of condition number one true. Is there a proposed agreement?
Yes, Your Honors, revocation in 6 years, in the Texas court. And the state's also gonna take into consideration NIMAG number 756-441 and NIMAG 756-440.
All right, that's 756-441 and 40.
Yes, ma'am.
All right, is that the agreement?
It is, Your Honor.
All right, Mr. Diaz, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes.
All right, the court will find violation of condition number one true. The court will grant the motion, find you guilty, revoke, sentence you to 6 years in the prison, give you credit for any time served, take in consideration NIMAG number 756-441, 756-440. Did you pay the $57 to SAPD for laboratory testing?
Yes, I did.
All right. All right, is there anything else with regards to sentencing?
Judge, just with regard to sentence for credit for time served, I understand from the court's clerk that he has 157 days in. We'd ask for credit for that. And then he did do the SATF program and was successful released from that after doing 118 days in that program. We'd ask for credit for that as well. The total would be 275 days.
All right, probation, did he successfully complete inpatient treatment with SATA?
Yes, sir.
All right. What will give you credit for inpatient treatment? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
33.
All right, so you have to ask yourself, is 6 years of your life worth what you did?
No.
All right, so you've got to start making better choices. Otherwise, you're going to wake up and you're going to find that a majority of your life has been spent in custody, and you're going to end up what they call institutionalized, where you can't make it in the real world. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge. May I be excused?
Yes, and how are you feeling?
I've got to go to physical therapy this afternoon and then on Wednesday as well. Pain got a little bit worse, mostly in the middle of my back.
Yeah.
Is the problem. And then the shoulders. So
See, I always tell my mom, and I have to tell myself, don't rush. My mom says I walk too fast. I'm like, slow it down, don't rush, and go with the fall. The only thing you should be protecting yourself from the fall is your head, but otherwise just go with it.
yeah, and unfortunately I tried to, brace myself and then bam, it the head's fine.
Mhm.
The head's fine. The rest is all broken. And it just because I fell this way,
Mhm.
it all just reverberates this way.
Oh.
Through my shoulders, hips and lumbar, so
Well, take care of yourself.
I'm trying to.
Okay.
Thank you very much, Judge. I
Thank you.
appreciate you asking.
All right, have a good one.
You too.
All right, are you all ready on John Michael Garza?
And Judge, the interpreter is here.
Oh.
Please.
Hi. All right, do y'all have the plea paperwork ready?
I discussed for him and Judge.
Okay, well, once they're ready on that, we'll take it up.
And I have an announcement when you have time.
Okay. Lindsay Hernandez.
Yes, sir.
Lindsay Hernandez, come up. Hi. All right, and counsel, if you'll introduce yourself to the court reporter.
Of course, yes, Renee Munoz, here's my card as well.
All right, so where are we on this case?
Judge State's made an offer.
That is correct, Judge. State has made an offer. Client would like a trial date regarding this matter.
All right, and you have all the discovery?
Yes, Judge.
And counsel, if you'll make sure that you give them an acknowledgement of discovery?
Yes, Judge.
All right, so Ms. Hernandez,
Yes, ma'am.
I allow people a chance to think about the offer. Did they make it today?
They made it today. Yes.
All right, so what we'll do is we'll recall her back. If you're available, counsel, for the week of July 22nd, and she can let the court know then.
Sure, of course, Your Honor.
All right, Ms. Ferguson, can you recall Hernandez back for the week of July 22nd? All right, so we're going to come back on July 22nd. On that day, you need to let the court know whether or not you've reached an agreement. And then after that, it'll be your trial setting. Do you understand? Yes. All right. Do you have any questions?
No, ma'am.
All right, thank you. And Deputy Laura Hernandez is completed.
Yes.
Your Honor, and we're ready on that previous one of the Michael Hernandez as well.
Okay.
Your Honor.
Michael Hernandez. All right, on this case, where are we on discovery?
Yes, so I think say we've handed over all the discovery that we have. The central issue is that there's a video that apparently shows everything happened. I just want an opportunity just to watch it. I just didn't get it done here.
That's correct, Judge. The discovery looks intact, but it's my understanding they want to get a better sense of the video. Can that be placed on the same date of July
Yes.
22nd?
All right, we'll bring you back on July 22nd, okay?
Thank you, Your Honor.
All right, are you a Spanish speaker?
No.
Okay, all right.
Appreciate
Okay,
it, Judge.
because he didn't respond to me. And I was like,
sorry, man. I can't see. I'm legally blind. I don't have my glasses.
ah, okay. Do you have your glasses at the jail?
They took in from me in an assault. So I was there.
Counsel, if you want to check
Yeah.
on Deputy Laura, he says he needs glasses and he has glasses at the jail, but they took them. I don't know, were the glasses allegedly used in the assault?
I was wearing them when I got assaulted. And
They were, I think.
no, I came in. I'm talking about the assault inside.
Inside the jail?
Yeah, I got
So
assaulted.
that's what I'm saying. So,
That was 2-3 weeks ago, and I tried putting in, and nobody can find them.
all right, can you see if they can find his eyeglasses? He said they were missing at the jail.
Do you have any at home that a family member can possibly? Those are the ones.
You could just get some new eyeglasses.
They're-
Need a minute, a quick call.
Okay.
Because if the glasses were new.
Do you know who I'll contact to bring this attention to at the jail or just administration?
It just depends upon the glasses we work, because they need to use contraband and to use it.
Depending if they're sharp or something. Okay, I'll look into it, Judge, to see at the jail what they recommend.
I was assaulted by inmates, and they got picked up. I got separated from my group. I got moved so that somebody kept them. I tried getting them. They said somebody
So
picked them.
there was a fight in the jail and then they separated you all out and then they asked you questions and they took the glasses. Okay.
All right, and
All right.
counsel, if for some reason you're not able to get in contact with anyone, let me know. If you have no objection, I'll call over and see where his glasses are.
Oh, that would be amazing. Yes, Judge.
Okay,
Appreciate
sure.
that.
I'll do that as soon as I have a break.
Oh, no problem, Judge. And I don't mind trying it out.
Number so he could contact.
Yeah,
me.
I'll
Okay,
try first.
awesome.
I know you're busy, so I'll go ahead and get on that, Judge. No problem.
All right, thank you. Who's here on Andrew Leha?
Oh, that's me, Judge. Good morning, Judge.
Good morning. And after I do this, we're gonna take up the Spanish speaker.
Okay.
Yeah, where's Leha?
Leija, I guess, I don't know if he was already on bond or he was detained already. He was out on bond. I had 2 warrants, county court 2 warrants, so they've taken him back. And so now I have an offer from the prosecutor.
Well, I mean, is he at the Bear County Jail?
He's lost in the here.
Oh, okay.
So
All right, we can recall this.
well, we would have to recall it, Judge, this week because then I have a vacation news because I'm leaving the country.
All right, are you gonna connect with Richard? who keeps
No,
posting them?
we're doing a pass the baton.
And explain to me, I'm always fearful for Richard when he's driving in different countries.
know.
And then he's saying the road is so tiny.
Yeah, no, and then on this trip, he just told me I'm leaving. He didn't tell me where he's going. He gave me his list of CPS cases. Didn't even, I mean, he just emailed them, so I couldn't
It's like,
like
bye.
discuss them or anything. And he was off, and I'm like, where is Richard Garcia?
Yeah, we should do that.
Yeah,
Where in the
in the
world
world
is
is
Richard
Richard
Garcia?
Garcia? Yeah. Finally, everybody on Facebook was like, oh, he's here. And I'm like, that's so funny. So he shows up and I'm like taking off.
Yeah, okay. Deputy Laura. Will you be able to get him back tomorrow, you think?
We could talk again tomorrow.
Norma, on Andrew Leha, if we're gonna recall this for tomorrow,
That would be perfect, Judge, because then I know where he wants to head.
okay.
Yeah, because I've had the jail visit, but it was before I had a plea and before he had these other two filed.
Okay.
Yes. Yes.
All
Okay,
right, so we'll
I'll
bring
be
it
back
back
tomorrow.
then. All right.
Thank you,
thank
Judge. Okay, thanks.
All right, who is here on Juan Carlos Soto Victorino?
For President Judge.
From counsel, is this a plea on one case?
Yes, Your Honor.
Thank you. Are there any applications?
No, Your Honor.
All right, the court is calling 2023. I'm sorry, Renee, if you could ask that, they'll just move your client on the end. All right. Court is calling 2023 CR 2763A, State of Texas versus Juan Carlos Soto Victorino. Can I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense?
Good morning, Judge. Alfonso Cabañas and Ashanti Brown for Juan Carlos Soto Victorino.
And we have an interpreter. Could you raise your hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
Carmen Tarragona Nazais.
All right, and Mr. Cabanos, I know you introduced the person who's with you.
Yes, Your Honor.
All right, would you like to make the announcement for the record?
Ashanti Wilson, Alfonso Cabañas for the defendants.
Ashanti Wilson and Alfonso Cabañas for the defendant.
Thank you. All right, counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to review all of these documents with your client in Spanish?
I did, Your Honor.
All right, and Mr. Victorino, all of the documents I'm going to review with you are in English. Were those documents reviewed with you in Spanish?
Yes.
All right, counsel, have you received all of the discovery and did you review it with your client?
Yes, Your Honor, I did.
The court will find that the state is in compliance with discovery. Mr. Victorino, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
See.
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Waiving counts 2 and 3, Your Honor, proceeding on count.
Any objection?
No objection from defense counsel, Judge.
All right, off the record for a moment. I know that Odyssey does weird things. So anyway, the paperwork has all of these listed. I don't know if y'all wanted to scratch through those because I don't want him to assume that he's pleading to everything, although everything is listed.
Yes, Your Honor.
So I don't know if y'all wanted to remove that or not. Thank you. All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
See.
Yes.
Did you understand in count 1, you're charged with aggravated kidnapping? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
See.
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
See.
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Sí.
Yes.
Did you understand by entering this plea, you were giving up those rights?
Sí.
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Sí.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he did.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I do.
Mr. Victorino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Has anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Sí.
Yes.
Are you a US citizen?
No.
No.
Defense, have you had an opportunity to speak with your client about the impact this case will have on his immigration status?
Yes, Your Honor. I consulted with my client regarding his immigration status. He's very well aware of what the consequences of his plea mean on his immigration status, and he understands that he is likely to be deported from this country.
Mr. Victorino, do you understand by entering this plea, you can be deported from the United States?
Sí.
Yes.
Did you understand you may be denied re-entry or naturalization?
Sí.
Yes.
Knowing that, do you still wish to continue with this plea?
Sí.
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Sí.
Yes.
According to the plea, state is proceeding on count one. Punishment is to be assessed at 10 years in the prison, and there are no applications. State will take in consideration 2023 CR 2764A. Did you understand that to be the plea?
Sí.
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Sí.
Yes.
And did you sign it?
Sí.
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Okay.
Did you understand?
Sí.
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense in count one, how do you plead? Guilty, not guilty, or no contest?
What?
Oh, how do you plead? Guilty, not guilty, or no contest?
Culpable.
Guilty.
State any evidence.
Contained in exhibit 1 and attachments, Your Honor.
Any objections?
No objection to states one and attachments.
All right. And state, have you had a chance to speak with the complainant?
No, Your Honor.
All right, thank you. You may be excused. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Sí.
Yes.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Sí.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Okay.
No, did you understand?
Sí, entendí.
Yes, I understood.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes.
All right, the court will find you guilty. Court will sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. Take in consideration 2023 CR 2764A. There's to be no contact with the complainant and the following individual: Rosa Sanchez, Lazaro Yanari, YONARI, Espinoza Ramos, Fernando Espinoza Ordaz, ORDAZ, Lazaro Alfonso Estrada Perez, what is your relationship to Jose Jarrett Soto Victorino?
Who?
Jose Jarrett
Jerry.
Soto Victorino.
Nada. Nothing.
All right, there's to be no contact with Jose Jarrett Soto Victorino. And once you've served your sentence, you're not allowed back in the United States.
Okay. Okay.
And also, I'm sorry, and there's also to be no contact with Thazia, THAZIA, Nicole Loya Almendarez. All right, is there anything else with regards to sentencing, counsel?
Not from the defense, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
See,
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Okay.
No, do you understand?
see,
Yes.
All right, thank you.
thank you, Judge.
Thank you. Who is the other person with the interpreter?
Your Honor, but we still need to go over the paperwork, and I can do that really quick.
All right,
Your Honor, may I approach?
yes. Thank you.
She's not gonna come, and she's asking me if I can turn or what.
Who's here on Zion?
Thank you.
Taylor, thank you. Izon Taylor? I'm sorry, Zion?
Zion, yeah.
All right, thank you for dressing appropriately for court. All right, today is plea deadline date.
We're not gonna have an agreement today, Judge.
All right, I'll need a jury trial. State, how long do you expect this trial to last?
Probably 3 days, Your Honor.
All right, Ms. Ferguson, I need a jury trial date for criminal trial division, 3 days. September 3rd? All right, that will be your jury trial date. All right, once you sign the reset form, you're excused.
Thank you,
And
Judge.
state, if I do have the acknowledgement of discovery, there's been no additional discovery downloaded, has there?
I think there's been one thing, but
Judge, I've attempted to research that question for over a week, and the system is down every time. It's been down at least the last 3 days, that I'm aware of.
Yeah.
That's been frustrating.
All right, so if you'll contact the state and ask them, let them know what is it you're specifically looking for, and maybe they'll be able to get it for you.
I will do.
All right. All right, thank you.
And did you want, other than the reset form, did you want us to sign anything else, Judge?
Oh, no, just the reset.
Just the
form.
reset form. Okay. Thank you, Judge. Hernandez.
Who's here on Nicholas Courtney?
I am good.
Are you all ready to proceed?
We're not, Judge. I was informed that he has a incompetency hearing on July the 16th of this month.
All right, come down, Mr. Courtney. And when is the competency hearing scheduled?
July 16th of this month, 9:30.
All right. Ms.
Judge-
Ferguson, if you can recall this back on July 18th, we'll see what the results are for the competency.
Thank
All
you.
right, we're gonna bring you back on the, I'm sorry, July 18th. We'll bring you back on July 18th, okay? All right, do you have any questions? All right, thank you.
May I be excused?
Yes. Probation, Courtney is gonna be recalled for July 18th. If you, yes, it was. All right, who's here on Ruben Solano? Yes, Mr. Solano, come down.
Good morning.
Good morning.
Your Honor.
Good morning.
How you doing?
Oh, I'm doing great. How are you doing?
I'm great, man.
All right, so where are we on discovery?
I'm good with discovery on the drug case, which is set today, but my client also has an assault family violence second in your court. It's not set because it's not indicted, but can you bring him back Thursday? The state said they can bring their file. We can try and work something out.
But I can tell you we're not gonna be able to do anything. We only have the warrant, like the arrest paperwork. We have no further information right now. Because it's that new. I had intake check into it.
All right, what I can do is I can recall it back for the last week in July.
Okay.
Last week of July?
Yes, sure.
All right, Ms. Ferguson. What date? All right, we can come back on July 30th. All right, and Mr. Solano, your attorney, I'm sure doesn't want to go forward on any cases where she has no information on it. That would not be good for you. This is me making assumptions, but all right. So we'll bring you back on July 30th.
Yes, sure. Can it be the 31st? It's a Wednesday instead of
It
a
would have to
Tuesday.
either be the 29th or August 1st.
I'd love the 29th.
All right, Ms. Ferguson, can you put it on July 29th? All right, we'll bring you back on July 29th.
Thank you.
You're welcome.
Your Honor.
Yes.
I want to make you laugh. Say, can it be back on the 30th, like you said?
Oh, sure.
I just looked at my 29th day and it's crazy. So
Okay.
30th, yes.
Yeah, the 30th is fine.
Thank you. I'm
You're
sorry.
welcome. No problem.
So we're good.
Yes, the 30th.
Deborah Burke, B-U-R-K-E.
Jose Gonzalez. Review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney. Did you understand it?
Yes,
And did you sign it in all the appropriate places?
yes,
Did you understand you're charged with evading arrest, detention with a vehicle as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
yes,
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes,
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
No, Your Honor, unfortunately not.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, have you been able to confer with your client the impact this will have on his immigration status?
Yes, Your Honor. And I also have conferred with his immigration lawyer, and I have admonished him on the adverse consequences that this plea would have. Despite that, he believes that this is in his best legal interest. And despite me telling him that this is deportable and will cause deportation, despite that, he feels like this is in his best legal interest and this is what he wants to do.
All right. Mr. Herrera, do you understand by entering into this plea, you may be deported from the United States?
Yes.
Do you understand you may be denied naturalization?
Yes.
Do you understand you may be denied re-entry?
Yes.
All right. And are you here legally?
No. Legally?
Yes.
No.
All right.
Judge, I think there may be some status, I'm not really sure though, with the wife. And just so the court is aware and so the record's protected, there was an offer made at one point in time to reduce this to a misdemeanor, but I had not been able to confer with the immigration lawyer. By the time we got to this court and it was with an indictment, the offer had been pulled. That misdemeanor would have been fine, but now we're kind of, rock and hard place. There's, in my opinion, sufficient evidence. I mean, this is what he wants to do.
All right. Is that correct?
Yes.
All right. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration County Court for cause number 669867. There's to be restitution of $1,016.97 to Southwest ISD. Did you understand that to be the plea?
Yes.
Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None were necessary, Your Honor. No.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation and 150 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Contained in exhibit 1 and attachments, Your Honor.
No objection.
All right. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
That he's really sorry that this happened, and we just ask that you follow the plea bargain.
All right, Mr. Herrera, how old are you?
34.
All right, why were you fleeing?
I don't know.
Okay. Do you have any children?
Yes.
And what are their ages?
6 years old.
Okay. All right, this is what the court is going to do. The court is going to sentence you to a $1,500 fine. That'll be probated. 3 years deferred adjudication. Take in consideration County Court 4 cause number 669-867. There's to be restitution of $1,016.97 to Southwest ISD. Regular reporting by Zoom or in person. Regular random UAs. The reckless driving course. I'm sorry, defensive driving course. No illegal re-entry into the United States. I'm going to give you 30 days as a condition of probation. And the TAP evaluation will take place in custody. Follow TAP recommendations. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. 150 hours of community service restitution. I'll order parenting classes with compadre y compadre. Once he's completed that, the parenting classes will be, I'm sorry, the community service hours will be deemed satisfied. Field visits 1 time per month for 3 months. Probation, is there anything else? Is there anything else from the court that you need in order to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Your Honor, I apologize for interrupting, but on that point, there is one thing that I would like to clarify. If I heard you correctly, when you stated the length of the term of supervision, you said 3 years.
Yes.
And I believe our agreement was for 2 years. Did you intend to depart from the agreement between the state and the defense?
Yes, because that's outside the agreement. Yes.
Understood, Your Honor.
Well, Judge, let me ask him if he wants to withdraw his plea then, because that was.
No, that's outside the agreement. There's no withdrawing of a plea on that,
Oh, well,
because those conditions are not binding upon the court.
okay, maybe excuse me.
Yes.
Thank you.
All right, thank you.
Tap in custody, tap.
Yes, and it's going to be 30 days as a condition. Yes, he's going into custody
Yeah,
now.
well, that, I mean, that was totally unexpected and it wasn't also part of the agreement.
I understand. He's going into custody today.
Thank you very
All
much.
right, thank you. All right, we'll be back at 1:30. Thank you. Yes.
What looked like a routine plea hearing quickly became a serious reminder that probation is not a free pass. Charles Guy Jr. appeared in court facing a state jail felony theft charge involving an aggregated amount. He chose to plead guilty, and the court reviewed the agreement carefully. Under that deal, Guai would receive a 2-year state jail sentence, but instead of immediately serving that time behind bars, the sentence would be suspended and he would be placed on probation for 5 years. He was also ordered to pay a $500 fine and, most importantly, $6,136 in restitution. But the judge made it very clear that this agreement came with serious responsibilities. The prosecution noted that Guai had a criminal history, although the restitution agreement played an important role in reaching this resolution. The judge accepted the guilty plea and followed the agreement, giving him the opportunity to remain out of jail while completing 5 years of probation. Then came the warning that could determine Guai's future. The judge explained that simply waiting until the end of probation to deal with the restitution would be a dangerous mistake. Even if he follows every other rule, failing to make